So there are big changes ahead, and Queensland has new property laws. Today we're going to talk about what that means for buyers and sellers, because this is a really important information. So Mish, thank you for joining us. I mean, this is your podcast. I don't know why I'm saying thank you for joining us on your own podcast, but there's some pretty big news that is shaking up Queensland's property market. And we're going to break that. Well, not we, you are going to break down what that actually means for us today.
Well, I should be saying thank you to you, Sam, for hosting our podcast today. It's been quite an interesting time. So by invitation, I got invited to a presentation about the new laws that have actually just come in. They came on 1st of August, and I've got to say, I'm actually really pleased that these laws have come in, because it's about time, you know, the sellers take responsibility for what they're selling. I always found it really bizarre. All the other states that you buy in, they have to do disclosure, documents and forms and supply you everything. In Queensland, never had to. So now that he's coming in.
I'd always thought of Queensland being the wild, wild west of real estate. And then when I was looking over the notes for today's episode, I did breathe a little bit of a sigh of relief, like you did. So why don't you start off by sharing what's actually driving these changes?
Well, look, I think probably largely that we've got a lot of interstate buyers that have been buying in Queensland. And I think a lot of them have been asking, why don't sellers have to disclose this information? It's just, since when do you buy a property and you have to do all the digging and the diving and the delving to find out, to go hunting after the red flags? And realistically, I mean, you can be $10,000 into due diligence where you find something that is really unacceptable, and you've got a seller that just goes, well, take it or leave it. It means that you as the buyer have copped it, and you've either got to suck it up or negotiate it if you can. But if the seller's just kind of going, not my problem, take it or leave it, it is what it is, it makes a huge difference. So this law is going to make a massive difference, I think, when now that sellers are being put on the spot and they're squirming. They really don't want this, because, as you say, it's been the Wild West in Queensland for such a long time. It's now time to step up and get these disclosure statements up and running, and dig up all the information and give it to the buyer so that the buyer's not coming in blind.
Sounds good to me. So let's start off with exactly what do sellers need to be providing under this new law?
Okay, so this is a little bit of a bitter pill for me, because I don't feel as if it's enough. But
interesting.
Yeah, and I'll tell you why. So it's a great question, Sam. There's a standard form, and the lovely thing about buying in Queensland is that Queensland does have standard documentation, which makes it pretty easier. Your contracts are a hell of a lot easier to navigate through, and we know that the legals are pretty much the same. So they brought in something called a Form 2, which is now going to be attached to the Form 6A in commercial, which means that that form has to accompany current title searches and registered plans. Now, previously, what would happen is the buyer would have to go and do all those title searches and plans. Now the seller has to do.
Crazy. That's just on its own. I'm sorry, that's crazy.
It is. It is absolutely crazy. I mean, it really is shifting the responsibility to the buyer. Now it's shifting it back onto the seller, which under normal circumstances, why has it taken so long for this?
Right?
Hey, I mean, seriously. Okay, so it's title searches, registration plans. It's disclosure of encumbrances like easements, leases, covenants, whether registered or not. So a covenant is an interesting thing, because it means that you could be buying a property where the seller made an arrangement with a neighbor 40 years ago that they can use your driveway free of charge. So for instance, if two properties are pretty close and you've got one shared property, one shared driveway, and that driveway effectively belongs to the property that you're buying, and there's no registered easement on that driveway, but as a good neighbor, you've allowed your neighbor to use that. Okay, now you're coming along and you're buying that, and previously the seller wouldn't have to disclose to you that he's got this arrangement with a neighbor, which means that you come along and you put new gates up and you've got an electronic key on it or whatever it is, and suddenly the neighbor's going, hey, mate, what's going on? Why are you doing this to our driveway? You know what I mean? Or our easement down. So it's those sort of things where now they have to tell you, by the way, we do have this arrangement with a neighbor. We need to speak to them, blah, 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 sort it out. Okay, so it's little things like that. I'm just giving you one silly example, but there are many that we've come across. Sometimes we have those across 2 or 3 properties. If your property is landlocked, so it's got no access from the back, you might have an easement, or you might have a covenant with 2 or 3 neighbors, 2 or 3 owners. And you could have where one of those owners just decide, nope, they're not in agreement with the sale. Sorry, you can't use that access way anymore. Things happen. So now at least they need to disclose that information. The other thing that has never been disclosed is zoning, planning information, and statutory notices. Very, very interesting, because zoning, for instance, zoning changes all the time. Planning information. Let's talk about resumptions. I was having a conversation with, I can't remember who it was, during the week, and they've built these buildings along a path that ultimately the Queensland government wants to turn into a freeway. So they've built these buildings there. Nobody's told them that the zoning's going to be changing, and the planning is that a freeway is going to be going through there, which means that their properties are going to be resumed.
Wow.
You're going to need a resumption lawyer to fight that. So
it's huge.
It's massive. It really is massive. So those kind of things are now a seller has to disclose to you, which I think is way overdue. You've got environmental and safety documents. For instance, vegetation protection order on trees. I was looking at a property a couple of weeks ago, retail property, very nice, but the whole back section of it, which is a large section, it was about 2,000 square meters, and about 1,000 square meters of it had trees in it. And straight away, I said to them, do they know whether those trees are protected? Because this is a huge, it's a huge issue that usually developers would get involved in, because developers buy land, it's got trees on it and animal rights and all that sort of things, or permits. Previously, it's up to you to go and hunt and look for it. Now the seller needs to tell you.
Wow.
Couldn't come fast enough.
That's quite a lot that you're talking about there. What happens if the seller doesn't provide any of those documents?
Well, they have to.
Maybe it's just 1 or 2 of them.
Look, if they know that these restrictions are on that property, then it becomes a legal issue, because they have to provide that. If you're selling a property, let's say for argument's sake, and you don't provide this information, let's say like the vegetation protection order. In fact, I can tell you a case just 2 months ago where somebody bought a property. And the reason why I'm telling you about the vegetation protection order is because it was a true life case that happened, and I'm remembering it. And it's been a huge issue because there's a massive tree in an area where, quite honestly, it really doesn't belong there. And the previous owner loved the tree and went ahead and put a protection order on it, did not disclose that in the sale. It was pre-1st of August. The buyer has bought the property. The tree is ailing. It's got massive problems. They had to bring an arborist in. They've had to get an arborist report. And now they're having to get permission from council to treat the tree or dispose of the tree. We're looking at between $15,000 to $20,000 for that little process.
I was just about to say, all I can hear is ka-ching, ka-ching, ka-ching.
Correct. And like I say, this transaction happened pre-1st of August, and the seller's going, not my problem.
So what can you see changing? Like, obviously, we know that there's changes. You've just talked about them. But how do you think that that's going to impact everyday buyers and sellers, like on both sides?
Oh, look, I don't see it being a massive problem. The sellers are probably going to be a little bit more irritated by the fact that I have to do it, depending on who their agents are. You know, if an agent is sitting with the seller and saying, look, it's now law that you have to provide this, well, there's nothing they can do about it. The law is the law. You know, you can't get away with it. And with all due respect, this has been happening for years in other states. So what's the difference? You know, it just means that the seller needs to be a little bit more responsible for the sale of their property. And if they want to sell, well, this is what you got to do to sell. You know, I always speak to people about the difference between preparing a property for sale versus just going out there and offering Joe Blogs money for their property. Because it's all very well, Joe Blogs might say, whoa, you know, the last guy offered me 500,000. Now you're offering me $1 million. Hell yes, I'll take it.
Yeah.
But do you know what you're buying? You know, because if the seller doesn't have to disclose all of this to you, they can just say, there we go, deal done. Thank you. Bye-bye. I'm out of here. Take your cash. Now there's an actual law around it, so they can't do that anymore.
So for buyers agents, maybe any other professionals that are in real estate, how is this going to change your role?
Look, I think it should make our role a little bit easier. And I'm going to speak from the buyer's perspective, because previously we had to get our solicitors acting on behalf of our clients to do all of this information, which means that every search that you do, you know, it's ka-ching.
Money. Yeah,
Yes.
exactly.
So the buyer, and that's the example that I gave you in the beginning, the buyer is paying their legal solicitors for searches, for finding this information. Also, from a due diligence point of view, if it's not a legal issue, then it's due diligence that essentially has to be revealed to the buyer, which makes it a little bit easier for us, yes. And to be quite honest with you, I think it's more fair.
Yeah.
You know?
I think so.
Yeah. In many cases, the agents are stepping up and spending time with their sellers and saying, you need to disclose this information, or the agent goes and finds the information. The agent is actually assisting, depending on the type of agent. But most certainly, if I was an agent, I would definitely be assisting the seller to put all this information together to make it more transparent.
Yeah.
I think that's the whole thing, Sam. Where this is going is transparency.
And like we said at the beginning, about time, really.
Yes, it certainly is about time. Oh my gosh, have I seen some doozies in Queensland?
Bet you have.
Yeah, I said to you earlier that I think I'm in agreement with it. However, I don't think it's strict enough. I think there's a lot more that should be disclosed. For instance, I would go as far as saying building and pest. The seller should do a building and pest with all due respect and be presenting that to the buyer. Valuation, same thing. I really feel as if the seller should be doing that. But I think that's not going to be in my lifetime in this, not in Queensland.
Yeah, at least it's a step in the right direction.
Yes.
And it does sound like it's a game changer.
I think so.
Yeah. Like you said, it sounds a lot more fair.
Yeah.
Do you have any final thoughts for buyers or investors who are listening right now?
Look, I'm a little bit like a bulldog stuck on with my teeth in it now when it comes to building and pest and valuations. And I just want to explain to the audience why I'm saying that, because You could have 10 people looking at a property and 5 people interested in that property. And the only way that you can move forward is to have a building and pest done. Or you could do building and pest, you can get the valuation and you find something. Let's say your valuation doesn't stack up, which is often happening in the current market. You can't get the finance, property falls over, boom, you've just lost probably about $3,000 or $4,000. If it's a cheap property, could run up to 10, 11,000, depending on the value of the property. Your next buyer comes in, same thing happens, which means that the seller doesn't have to take any responsibility for the fact that they're overcharging for the property and that it's got building or termite issues, building pest issues. And it could mean that that property has undergone the same process 2 or 3 times with 2 or 3 buyers, all of them getting to the same place where the property's falling over. So think about it logically. If you're selling a property and the deal does fall over once or twice, it is an expensive process because you pay for the legals from this perspective. Why not just do the building and pest, have a valuation, present it and say, it's open, it's transparent, this is what it is, this is what we've uncovered, I've already knocked this off the price, or we're wanting X amount, we'll reduce it to Y, and let's get the deal done.
That makes so much sense because it's all time is money, right? And just being able to move it along just makes so much more sense to me. And as a purchaser, I would prefer to see that.
Absolutely. I think any purchaser would prefer to see that. And it just makes it more fair and equitable. Makes you feel as if you're not having to bat seals to try and buy this property, or you don't know what's going to pop out in the background after you've bought the property. It's just moving into the new age. Things should be far more transparent. I mean, everything nowadays is you can't hide from anything. It's all on social media anyway.
Right. Yeah, exactly.
So why not make this process more transparent, and go the full hog? So I agree with REIQ, what they've done. I think it's a step in the right direction. However, I don't think they've pushed it far enough. I really think there's space for that, just that additional disclosure of, and look, we know valuations change. Banks will change their valuations, but if you've got a valuation that you could present to a buyer and say, look, the property's worth 5 million, then the buyer can, have their own valuation done.
Love it.
Yeah, the responsibility goes to the valuer, and the responsibility in building and pest, the responsibility goes to the building and pest. So why not? Why not do it?
Just builds trust right from the beginning is my thought on that. If I was going to purchase a property and that was all done, I'm more likely to go into or enter into that conversation with more trust. It has me in a different frame of mind.
It really is. It really is a different frame of mind. It's a different frame of mind for the seller and a totally different frame of mind for the buyer. I mean, with all due respect, if I was selling a property, I would actually prefer to be far more transparent and show them that, have a better relationship with the buyer, seriously. But I think there's always been this sort of, separation. It's been a challenge rather than a
collaboration
between the and the seller. I'd like to see a lot more collaboration happening rather than challenge. So
I love that.
Do you think you're going to see it in my lifetime, Sam?
Probably not. The world's full of way too much red tape, isn't it?
I don't know. I think we're going to be speaking to REIQ to maybe extend that a little bit further and bring that in. I don't know why they didn't. And I can't remember. I don't think I asked the question at the time, but I really do think it's necessary. So
yeah. Well, I love that you have brought this to the table because it is so, it's just gone through on the 1st of August. So really appreciated your insights and thanks for breaking it down so clearly, Mish.
Absolutely, Sam. And, if anybody wants to know more about it, reach out because I think this is really important to work with your professionals to get across all these changes. And stakes are high. There's opportunities out there, so do the right thing.
Yeah, don't get caught out.
No, absolutely.
Yeah.
So
thanks so much for joining us for today's episode on the Queensland law changes. We look forward to seeing you on the next episode of Revolve Commercial Podcast.